And that can mean a lot of nonverbal stuff. So posters in your office, your screensaver is a little saucy, forwarding inappropriate emails, social media posts that are not appropriate, text messages, etc. All that is a legitimate example of sexual abuse. And then also physical touching, hugging, etc., gesturing, rubbing shoulders. And for a visual, this is what it looks like. You may say, well, a hand on the shoulder is innocent. Well, if they tell you one time, don't do it, and then you do it a second time, and then they say, it makes me uncomfortable, the third time you could be in trouble. Myths. These are myths about sexual harassment. That only women experience it. That's not true. Research shows that 81% of women experience sexual harassment or assault, and 43% of men experience it. It can be white, black, rich, poor, Democrat, Republican. It happens to everyone. That most harassment charges are fabricated. We know that not to be true. Only about 10% of reported cases have been found to be false. 90% are accurate or legitimate. Women bring it on themselves by how they dress and how they act. Well, from my counseling perspective, counseling psychology says this is an ego defense mechanistic excuse. You just can't control your urges and your behavior. And whether or not people are dressing like they should, that's a question for a different area. And I do know that jobs do have some dress codes. Another myth is that women who complain are just gold digger types. They're looking for fame and looking for money. The truth is that an overwhelming majority of women would rather just avoid all of the media and the pain and the retribution and just keep it to themselves and not come forth. In fact, most don't come forth. Only 30% of women actually come forth. Another myth is that the number one reason for sexual harassment is sex. Not true. The main motivator is power and control. As employees, your employees have the right to complain. I'm assuming that I'm talking mostly to managers today. I'm going to tell them, we're going to tell them from our office to put their complaint in writing, that they have the right to ask their manager to respond with an appropriate intervention, and that managers must take the complaint seriously, and that they should request a follow-up in writing of what was done. Now, in order for management to be held accountable, because you can't always be everywhere and monitor everything that your workers are doing. So one, employers have to know or should have known what was taking place. And that goes, so if they don't know or they didn't, or in a position where they shouldn't have known, then that's one thing. Or if they knew and they failed to take steps to stop it. Continuing with management accountability. If the perpetrator is the manager, the company is automatically liable. If the perpetrator is a coworker, the company can be liable if the company was put on notice and did not protect the victim. Companies cannot bury their head in the sand and pretend not to know. So, retaliation is one thing that is not allowed. The company cannot deny an employee's right to complain. Nothing makes a jury more angry than when a company protects a harasser and then retaliates against the victim. That's a big no-no. Again, management must take the complaint seriously, and then workers have the right to consult the company's legal department. In our case, we have our own separate law department, or even hire a private attorney when things are not being handled by the normal manager or HR department route. Now, part two. Part two talks about residual effects of sexual harassment in the workplace. So naturally, there are legal implications, but there are also what we call human relations implications too. There's an emotional and physical price for the victim. There's a professional and financial cost for the victim. There's decreased company productivity, and there's the potential for lawsuits and loss of company reputation. All of that are reasons why we need to be a little bit more vigilant on what we're doing with this. So in terms of the physical price, these are some of the costs: stress, depression, anxiety, decreased anxiety, decreased production is what I should say, decreased confidence and self-esteem, loss of sleep, loss of appetite, weight fluctuation, nausea, headaches. Look at that list and it kind of makes me wonder if I should go back home and go back to bed. Now, a second problem is the financial issues that the victim has to go through. The worker's job performance and ability to be on task, complete task on time is impacted. The wages and benefits are impacted negatively. The worker's attendance and tardiness behavior begins to show. The worker gets a reputation for being a troublemaker. And then the worker's interaction with colleagues can sometimes cause withdrawal and problems regarding that. Okay, we're almost done. Coming to the end here. An harassing and toxic workplace can also cause high stress levels, higher employee turnover, crippling of team cohesion, increased hiring and training costs, and problems with recruiting top talent. You get the reputation of that's not a place we want to be. Lawsuits can be very damaging. A recent lawsuit in Florida was given to a person for $17.4 million. And then another one was given for $18 million. And this was the boss who retaliated against an employee who filed. So it can be very, very, very expensive. Now, I suggest that all of in job sites at some time, at least once a year, have some kind of sexual harassment training. And that training should include the adoption of a verbal, written, and posted zero tolerance policy, a clear definition of what constitutes sexual harassment so that no one is, confused about that, a description of the reporting process, what it looks like, identification of who's designated as the person that a complainant can go to, clearly outlining what the consequences will be if the policy is violated, and an outline of the remediation process and what that looks like. Now, for those of you who may be employees or middle management and you feel you've been impacted, you must find a way to get your power back. Remember, it's about power more than it is about sex. It's important that we learn as a society to turn bystanders and enablers into allies. I believe in the saying, if you see something, say something. Now, we also need to update and amend our current laws and practices. Now, a lot of people may not know this, and some bosses may know this next thing, so I'm going to have to duck and hide on this one a little bit, but many employment contracts have what we call a forced arbitration clause, and it's in fine print. And this can result in the employee abdicating away their Seventh Amendment rights to an open jury process. Number two, they don't get witness and deposition rights. And number three, in many cases, the company chooses the arbitrator, not the victim, or not both of them together. 4, there's not a chance for an appeal. 5, the outcome is kept secret. And 6, only about 20% of these hearings go the way of the victim. And I'm a strong believer that we need to amend this practice. Embrace a culture so that the corporate level is impacted and it's not just a few people fighting on the behalf of this thing. And then be honest, be fair, but also be fierce. In conclusion, there are no winners. Everyone loses in a sexually harassing and toxic working environment. The best thing for management and bosses to do is to get in front of it, get ahead of it, save yourself the headache, because we're in an era now where those rights are going to be protected. For those of you who want to file a complaint with my office, here is the contact information. And I believe that we're going to wait until the end before we take questions. So
yeah,
at this point, I'll turn it back over.
Okay, thank you, Dr. Thompson. That was fantastic. And are we going to be able to get a copy of that presentation to maybe send out to the group?
Why don't I send it to you?
Okay.
And then you can get it out to everybody.
I will do that. One of the things that I just wanted to follow up on, we mentioned that questions we'll take those questions at the end because we want to make sure that everyone has time to do their presentation. But we want to make sure that we are answering those questions. And so as you have questions related to any of this content, please put that information in the chat and we'll get to those questions here at the end. One of the things I wanted to follow up with you on, Dr. Thompson, was you mentioned, I mean, this presentation is based on sexual harassment, and we know that there's many types of employment discrimination, when we're talking about race and national origin and disability and things like that. What is your office seeing as far as trends go when it comes to employment discrimination? Are you seeing any emerging trends or patterns?
Yes. The biggest pattern that I've seen over the last 3 years has to do with disability, not making things quite accessible so that a person can come in and work the right way. We also sometimes, I would say, race and then gender. Those are the three trends that are the most, but we do get our share every now and then of sexual harassment cases.
Great. Yeah, thank you for that. And as we jump into these next two presentations, we're going to talk a little bit more and expand the scope of employment discrimination, talking about kind of some emerging trends, some updates when it comes to case law and things like that. Before we hand it over to Rob to do the next presentation, I just want to get a little bit of feedback from the businesses that are participating in this conversation. So I'm going to put a polling question up here, and this is going to help us understand who our audience is and how we can connect better with businesses as we do these workshops moving forward. And so if you wouldn't mind just putting what industry or sector represents the business or organization you work for, be great if we could collect that information and build out more workshops that are focused on what you need to hear. And so also feel free to email me directly, reach out to me if you have any ideas for topics or conversations that we should be having during these workshops. So I'll go ahead and end this polling question now, but it looks like we've got a good representation across a number of different industries and sectors. And then I'll add one more polling question to this before we get into the next thing is, how did you hear about the workshop today? So if you wouldn't mind answering that, whether you heard about us through the Department of Labor and Any Works, if you heard about it on LinkedIn, other social media, it was pushed out on Facebook a little bit, on the Heartland Workforce Solutions website or other. And for those that are answering other, because it's a lot, I'd love it if you could put that in the chat of how you heard about this workshop, just so that we know what's working and what's not working when it comes to promotion. So thank you for answering those questions. And I will hand it over to Rob Rowan here to add to the conversation about employment discrimination.
Awesome. Thanks so much, Stan. Good afternoon, everybody out there in Zoom land. I hope everybody's well. I'm going to start my share screen here. Maybe. There we go. Okay, so thanks, Stan, for having me here. It's always good to see you, and it's always nice to be thought of for something like this. I'm honored to be on a panel with Dr. Thompson and, of course, the all-knowing Ben Watson. My name is Rob Rowan. I'm Senior Civil Rights Investigator with the Lincoln Commission on Human Rights here in Lincoln. Up on the screen, you should see my contact information. That's my direct line. If after this anybody has any direct questions for me, feel free to give me a call. Also, there is my email. I'm very responsive to both, so give me a call, drop me an email. I love talking about this stuff. So what I'm going to be talking about today is essentially what discrimination investigations kind of look like, what they're like, and essentially how would they apply to business. Now, I'm going to speak fairly generally because I know there's a lot of you out there and I have no clue what everybody does. So I'm going to be as general as I can with this. So what LCHR does is kind of similar to what the Omaha Human Rights and Relations Department does, and similar to the NEOC as well. What we do is essentially two things. We do discrimination investigations, and we investigate complaints of discrimination within housing, employment, and public accommodations. We also do a lot of outreach work, training and education, such as being on panels, such as today. But we also do a lot of training for employers or housing providers that are looking to kind of broaden their scope and maybe do a little bit better with equity and inclusion training, diversity training, things like that. So it's kind of a shameless plug for me because I'm generally the one that's doing them. So if you want something like that done at your organization, give me a call. So with housing, it's a little bit different, as it relates to business in a way, if people are evicted because of a protected class, one of the protected classes that Dr. Franklin mentioned, in fact, that's not necessarily employment, I guess, but should that come up, give us a call. However, a lot of housing providers, such as, big companies, will have employees. And so employees of housing providers have the same rights as any other employee has in any other capacity. So always bear that in mind, that if there is any type of discrimination, essentially anywhere, give us a call. We can help out with that. Now, the investigation process, it's a little bit daunting, especially if you've never done or been a part of anything like that before. It's not really a courtroom proceeding. So if you ever get a serve from either the Commission on Human Rights or Omaha or NEOC, first thing that's important is that you don't panic. This isn't going to end up being like what you see on Matlock or Boston Legal, where it's guilt versus innocence and it's just a terrible experience. Most of the time, it's pretty straightforward. So just because you get a complaint on your desk that there was potentially discriminatory behavior happening at your business doesn't assume anything. It's just, somebody felt like they've been treated differently, and so they called us to file a complaint, and we just look into it. Another important thing to keep in mind is that we are a neutral agency, so we don't represent the complainant, and so we're not going to be coming after anybody, on behalf of anybody. We're on the side of justice, essentially. So when you get a charge, just either call and ask for clarification, or just, quite frankly, follow the words that are on the serve and the request for information. It's pretty straightforward. You'll see burden shifting at the top. So this kind of goes back to sort of my little courtroom drama thing there. The way these work is that complainants will make a complaint of discrimination. They don't really have to have really any evidence whatsoever. It's really just, I'm a member of a protected class. Something bad happened to me because of it, and others outside of my protected class are treated more favorably. So with that, we take that and then we serve the respondent or the business. And we say, okay, this is what they're saying. What say you? Now, they now have the burden of providing evidence that shows a legitimate, non-discriminatory reason for whatever action they took. The burden then shifts back to the complainant to provide evidence showing that there was cause to believe that discrimination took place. So burden shifting means you're essentially tipping the scales back and forth. So the whole process itself is people will call and say, I've been discriminated against. We say, okay, and we put together a charge or a complaint, depending on what area it's in. It's called something different, but it's all the same thing. So we send the request for information. We serve that upon the business, who is now the respondent. They then have a certain amount of time to reply. Usually it's about 10 days. Respondents almost always ask for extension, and we almost always grant it. So they are required, but we are a very accommodating agency. So if you need a little extra time, just give me a call. It's fine, not a big deal. Now, once we get that response, we do what's called the rebuttal interview with the complainant. And what that is an opportunity for the complainant to hear the response in response to their complaint. So we kind of do this tennis match thing back and forth. Now, once we do the rebuttal, we then generally have to do some more work. And that can be a whole range of things. It could be a range from, I think we actually have everything that we need, to multiple witness interviews. We might need to do site visits. Very frequently, we have to call the business and ask for more information because they didn't supply us with everything. So we're doing more and more work there. From there, once we get everything kind of sifted through, we put together a summary and the director reviews it, and then it finds its way to the commissioners to make their determination. Now, the determination in these cases either go no reasonable cause or reasonable cause that discrimination took place. If the case goes no reasonable cause, that's essentially it. And kind of like what Dr. Thompson was talking about, there's really no win in these things, but respondents look at no reasonable cause cases as a win because that's kind of the end of it. We don't have an appeal process or anything like that. Now, if the case goes reasonable cause, there's a couple things that happen. We'll try to work through some mediation and try to settle the case again at that point, or it could go to a public hearing, which is not really the preferred outcome for businesses. Now, the last point that you'll see there, it says settlement talks throughout. What happens parallel with the investigation is throughout the entire process, we're trying to settle the case. So at the very beginning, we send out notification and we ask both parties, are you interested in settling? And quite frankly, regardless of what anybody says, I ask every party if they would like to settle throughout the case. So a lot of times respondents think complainants are looking for millions of dollars in a settlement, when most of the times they're just kind of looking for perhaps 6 months of back pay. So we have these kind of negotiations throughout the entire investigation. And that is really, I think, the thing that affects the most within the business itself. So kind of the things that you need to kind of consider are time, money, training considerations, and perhaps an altered business model. As it relates to time, you just have to do this. It's sort of a cost of doing business. Most businesses aren't going to receive a complaint of discrimination from our office. It's just not going to happen. Statistically, it would be virtually impossible anyway. But if one does come in, please don't ignore it. Just take the time to fill it out. Most of the time, whatever investigator is going to be investigating the complaint is very easygoing and easy to work with. Quite frankly, I've worked for 2 organizations of the 3 that are kind of here today. And I know many investigators, we're just trying to do the good work. And so we're not going to be beating people up or anything like that. So just take the time to respond. As far as, time is related to what you got going on in a day, you can equate this to anything else that might be a variable that might pop up on a Tuesday afternoon. So treat it like a phone call, do the diligent work, and then we just kind of move on. As it relates, of course, to business, the number one thing, of course, is money, right? I have an MBA, so I'm no fool. I understand that people are in business to make money. So this is where you're going to want to start kind of weighing what your options are when these complaints come in. If you have an organization that has something like in-house counsel to where you're paying an attorney a salary who has an office at the business and this is just their job, fantastic, good for you. Just slide this on over to her and she'll take it from there. So you're not really paying any extra money at that point. If you're kind of a medium-sized business and you don't have in-house counsel, but you do have an attorney on retainer, this is where you're going to probably start paying some money. Depending on what your lawyer charges, my guess is anywhere between $100 to $300 an hour. You know, you might weigh that, that cost versus what the complainant might be interested in for conciliation. As I mentioned, a lot of complainants aren't really asking for the buku thousands of dollars that we see all the time in the news. They're looking for onesie-twosie thousands of dollars. And it might be more reasonable to just pay the settlement, squash the case, and it's over with. If you are a smaller business that has no access to an attorney and no interest in accessing an attorney, that's fine too. If you do retain an attorney, you're going to be paying, that money like I was talking about. However, also keep in mind that our process does not require the use of an attorney. In many cases, it makes things go much faster if lawyers aren't involved. I'm very sorry, Stan and Ben. So if you don't need an attorney or you don't have one, that's okay. We will also guide you through the complaint process as well. So if it goes towards the end and you get a reasonable cause determination or something like that, at that point, you might want to think about getting an attorney, because again, we don't represent any side, you included, and you might need to get an attorney at that point. But it's important to weigh what the complainant is looking for as it relates to a settlement versus what it's going to cost you to actually be a part of this investigation. If it costs $200 an hour and it takes a lawyer 10 hours to do the work, which is super quick, you're looking at about $2,000 versus if the complainant's looking for $1,500, you might just get it out of the way. And it's confidential. We don't release it to the public or the media or anything like that too. So keep that in mind. Now, training considerations and an altered business model. In most of these settlement cases, we always include some form of training, either for employment training. If it's a housing thing, we almost always will have some type of form of training involved. Generally, the trainings are about an hour long, and you get to deal with me for an hour and answer and ask me any type of question that you want. So that's something to keep in mind. It kind of leads into my last point here that talks about an altered business model. Now, this type of stuff is really not going to alter anything as far as like your cash flow statements or pro forma or P&L or any type of those things. But what you might want to consider is taking some of the focus from one thing and either directing it to the idea of equity and diversity and inclusion training, or at least expand it in some capacity. That's going to generally be better for your bottom line if you and employees are just better informed about this stuff. It does change pretty frequently. Dr. Thompson brought up the 2020 Supreme Court case of Bostock versus Clayton County. That essentially is a huge game changer in the civil rights world. So, things change. And if you don't know about it, then you might get dinged. So keep that in mind. Maybe tweak your business models a little bit. It won't flip it on its ear by any means. So that's pretty much it. Again, Rob Rowan with the Lincoln Commission on Human Rights. Drop me a call, drop me an email, whatever you want to do. I'm happy to answer any questions that you might have. So thank you so much. And Stan, I will turn this back over to you.
All right. Thanks, Rob. Definitely appreciate that. So as we were going through that, a lot of great information about what that investigation process looks like. How Rob kind of tried to take the scary out of things, and definitely these organizations that are speaking to us today, they also offer technical assistance to businesses and do quite a bit of outreach as well when it comes to providing information about how to stay in compliance with federal, state, and local requirements when it comes to employment discrimination. And so as we're moving on, I just want to make sure that sometimes we're throwing out words and things that can get confusing at times. So just going back to some of the basics of what's been talked about, when we're referring to complainant, that is the individual who has filed the complaint, the existing or former employee. When somebody references a respondent, that is the employer that the complaint is against. And then when we're talking about reasonable cause, that's that ultimate finding of that there is some level of discrimination that meets the letter of the law. And I don't know what the statistics are currently, but when I was with the Equal Opportunity Commission, the Nebraska Equal Opportunity Commission, the average number of cases or percentage of cases that went reasonable cause, where the finding met the letter of the law for discrimination, was somewhere in the neighborhood of 3 to 4% of the cases that were filed. I don't know do any of you have statistics on that? Is that pretty much current?
That's pretty current with us. We're running about 2 to 3% reasonable cause.
Okay. Cool. Definitely appreciate that info. I'm going to hand it over to Ben to talk about some emerging trends and some current case findings and things like that.
Sure. Thank you, Stan. Yeah. Can you hear me? Am I turned back on now?
Yeah, you're good to go.
All right. And everyone can see my screen. We're good. All right. Yeah, our numbers are about the same as when you were here, holding steady. But as you know, a lot of that is because a lot of cases that would probably go reasonable cause end up settling before they ever get to that point. And so that's why that number is often so low, is because a lot of those cases with strong evidence, the employer decides to settle the case. And so it just ends up doing that. Sorry, I'm having a little trouble with my screen here. I need to adjust it before I can get going. All right, I think I've got it worked out. Sorry. All right. Anyway, thank you again for having us here. I'm happy to be here today to share some info with you about our agency, what we do. I'm going to do a little bit of what we call legal updates on major happenings that may affect you all as employers in our states. First off, I do want to make a quick statement that I am providing information here and our take on things, and nothing I'm really telling you should be taken as legal advice, as I am not your attorney and I am not providing legal advice to you. If I were your attorney, you would be able to tell that, because I would be charging you a lot of money, and this is free. All right, so my name is Ben Watson. As mentioned earlier, I'm a unit director at the Nebraska Equal Opportunity Commission. You can find our contact information here on this page. I would encourage you to like our Facebook page for updates and information. We only recently started it because, as you know, social media is very new, and so we're just joining up ourselves. Also take down our phone and email here in case you ever need to contact us for any reason. I did just want to start out before we did the legal update with a little information about us. We are a state agency, and so we enforce our state's anti-discrimination laws in employment, housing, and public accommodations. So far you've heard from 2 city agencies, OHRRD and LCHR. They have jurisdiction in Omaha and Lincoln, respectively. Our agency, the NEOC, has jurisdiction in the entire state of Nebraska, including in both those cities, and of course in every other town and city and in between. All 3 of us partner with the feds in the EEOC at the federal level. And so together, all of our agencies work together, and we make up sort of a continuum of sorts of agencies that work together to enforce anti-discrimination laws and employment in various ways in Nebraska. And so it can get a bit confusing, because you're like, why are all these agencies doing the exact same thing? It's because the cities, the state, and the federal government all have anti-discrimination laws, and our agencies are all tasked with enforcing those laws at those various levels, and they're all very similar, and so we work together to do that, and also work separately at different levels. And so you do have to keep track of all those various laws, the slight differences between them, and then how they interact, depending on where your business is located and where you do business. So for the NEOC, besides investigating complaints of discrimination, our agency also works with complainants and respondents to come to settlements where appropriate. We also provide technical assistance to the public through doing outreach, like participating in this today, or through being available to answer questions, through contacts. Just you can call us up during business hours to ask questions, and doing other various presentations. That's just a little bit about our agency. All right, so on to a few relevant court cases that stuck out to me. Typically in a legal update like this, we'd go over every case in the jurisdiction, and it would take about an hour or two, and I do not have an hour or two, so we're just going to stick to a couple here, which kind of stuck out in the last couple of years. We're also going to talk about a bill which was recently signed into law, which passed through the Nebraska unicameral in this most recent session, which is going to be very important to you if you're conducting business in Nebraska, that our agency will be administering here. All right, so first up, Bostock. Both the previous presenters already mentioned this case, and that's because it's very important. Bostock will probably dominate any employment law discussion we have moving forward here for a while, because it was pretty important. The Bostock case was joined with two other similar cases before the Supreme Court, and it was to determine if Title VII federal level makes discrimination against sexual orientation and gender identity illegal in the workplace. And the US Supreme Court's answer was that yes, it does. Because any decision that is based on an individual's sexual orientation or gender identity is unavoidably based on their sex, was the basis of that decision. And so they gave some examples in the decision, just to throw out one to help you kind of understand the decision. So if a male employee is fired for being attracted to men, that decision to fire that employee was actually made because that employee is a man. Because you certainly probably have other employees who are attracted to men, those other employees just happen to be female. The difference with the employee you fired is that employee was male, and that male employee was attracted to males. So really what you fired that employee for was because of his sex. You fired him for being a male who was attracted to male, where you do not fire females who are attracted to males. So in the end, it's sex discrimination. Other than that logic of how this works and having to kind of wrap your mind around that and figure it out through those types of examples, this is not particularly difficult to work with or complicated to adjust to. That especially goes for those of you in Omaha, because as Dr. Thompson mentioned, this has been the law in Omaha for quite a while. For everybody else outside of Omaha, this is just, it is sort of like another protected class, but really it just falls under sex, and you just have to understand that sexual orientation and gender identity are protected, just like race, color, national origin, sex, every other area of the law. And so don't fail to hire people because of their sexual orientation, don't fire people because of their gender identity, that sort of thing. So in practice, it should not be too difficult to execute moving forward. Going a bit further back in time to those innocent years before 2020, we have a couple of 2019 ADA decisions that I want to point out from the 8th Circuit. So Nebraska falls under the 8th Circuit. So both of these have to do with essential job functions. So essential job functions come up often in our analysis of reasonable accommodations cases and other disability cases. And so defining what is and what is not an essential job function in a disability case can be vital when we're investigating in our agencies under the ADA, and also in your employment decisions when you're considering reasonable accommodations and other types of decisions under the ADA. The first case, which I should have looked up how to pronounce his name, Gardea, I believe, versus JBS, involved a maintenance mechanic, and he had a lifting restriction, which he wanted to continue long term. So he had been granted this lifting restriction short term, but he wanted to continue it long term. The company argued that lifting objects over 40 pounds was an essential job function, just due to the circumstances of their space. It was a very tight area, and their staffing, there was like no one else that could do it. The mechanic's argument was that lifting heavy objects was not an essential job function because it was not something his position had to do very often. It was not something he had to do every day or even every week. It was just a very occasional thing that he had to lift over 40 pounds. It was fairly infrequent, was the word they used, was infrequent. The employer agreed that it was infrequent, but said that the task was still essential because it absolutely had to be done when it had to be done. And it was that mechanic in his position who had to do it when it had to be done. So there wasn't really a way around it. The court did side with the employer. So the key takeaway here from this case seems to be that if you have a position that has an important task that a person has to do, even if it's performed very infrequently, so not very often, that task can still be deemed to be an essential job function, even if it is done infrequently. If you have other factors about that position and about that function that can show that it is essential. All right. The second case I wanted to point out in this area is McNeil versus Union Pacific. It involved a call dispatcher who was, she was temporarily excused from what was normally a job requirement, which was mandatory overtime. So this position she was in had mandatory overtime as a normal job requirement. But she didn't have to do it for, I believe it was a 2-month period. When that temporary excuse period was up, the dispatcher wanted to have permanent relief from overtime due to disability. So basically wanted to keep the job, but say, okay, permanently you don't have to do overtime anymore. But the employer said, no, mandatory overtime is an essential job function, so we cannot permanently excuse you from performing it. The dispatcher argued that overtime couldn't be an essential job function because the employer was able to give employees temporary breaks from having to do it because, for instance, they had just given her a 2-month break from doing it. The court, however, sided with the employer. So just because she had been given, or just because the employer had given the employee a temporary break from performing an essential job function does not mean that the function is no longer essential. So at first glance, since the employee lost, this would seem to be something that favors employers, and probably does. But I think it's also helpful to employees in a way, because I think it helps you as employers know. It provides you kind of a broader short-term a way to provide reasonable accommodations to people, as you may feel more safe excusing an employee from performing an essential job function for a short period of time without worrying that you are showing that the function isn't essential. So, you know, the employer here is safe allowing the employee to, for a short period of time, like 2 months, not perform overtime without making it so overtime isn't an essential function. So anyway, this case taken on its own would seem to indicate that short breaks may not make a job function non-essential on its own. There are many other cases that may affect you as an employer, but we don't have time today, so I'll be cutting myself off at those 3 examples. Again, a solid legal update is usually an hour to even 2 hours long, and I would encourage you all to seek such training out, or have, if you have a large enough company or actually have attorneys working for you, to have your attorney attend such training. I know the EEOC is offering their annual Excel conference, June 15th through 17th this year online. It's highly recommended, almost always includes a great up-to-date legal information. It's spelled EXCEL, and it's offered by the EEOC. If you just Google that, Excel conference, EEOC, you'll find it. It's not cheap, but you can, if you send 1 or 2 people to it, there's a lot of great information there. In addition, you can always contact any of our 3 agencies for training on a wide variety of subjects, including legal information. Next up, in local news, the state legislature passed LB 451 after passing a similar bill in the previous legislative session. This time the governor did sign it, so it will go into effect September 10th, 2021. This makes Nebraska one of 11 states in the country to have hairstyles specifically recognized as protected under an anti-discrimination law. If you're paying attention to national news or kind of pop culture stuff, you may have heard these referred to as Crown Acts. The main thrust here for you all is that the definition of race now includes characteristics such as hair texture and protective hairstyles. The new language specifically gives the examples of braids, locks, and twists as types of protective hairstyles. New language does include an explicit health and safety exception. So you as an employer can show that your policy is necessary, non-discriminatory, applied equally, and that you have made an attempt to provide accommodations for people. and that can be an exception. There also is a fairly broad-ish exemption for law enforcement, although we have kind of yet to see how extensive that exemption will play out. Since this hasn't even taken effect yet, no one's really challenged it, and we don't know how to work exactly. So while people could already file complaints with our agency, and I presume with the other two agencies, prior to this bill being passed based on discrimination due to natural hairstyles and dress codes and similar issues, this addition to our law does the important work of calling attention to what is the reality for many people in our state, and what they must deal with in their employments. So based on this being passed and it going into effect, it is our suggestion that employers take time between now and September 10th to revisit their dress codes and make sure that you are all in compliance with the new language in this bill before it takes effect. And if you have any questions on it, you can always give us a call, which I'm going to flash up our contact information one last time here at the end because I am done.
All right, thanks, Ben. And those employment or those case updates are so important. Just understanding what's going on and how things are being interpreted, because with the legal environment in the United States, the structure of that, that's how changes happen. Even though the law may stay the same, case updates can really change how a law is interpreted. And so understanding those and how case law can really impact existing laws is very important. And so I would encourage you to do the same thing that Ben encouraged you to do, is if you've got your legal team there with your business, have them attend some full-length classes related to case law updates as well as other legal updates on this topic, because with the time restrictions today, we obviously couldn't cover everything. So I just wanted to make sure that everyone had a chance to put any questions in the chat. Looks like we've got one question from Kevin. What happens if there's no settlement? So I think this is talking about reasonable cause. What happens next if we get to that point and there's no settlement? So who would like to answer that question?
Well, I can take that. If there is no settlement, with us at least, it'll go to a public hearing, and essentially a sorry, another I am there. A public hearing, individual will hear the case basically, and we'll make a determination on if somebody needs to pay out. So it could be a situation of a forced settlement in a way, but it can be a pretty good fine.
I definitely appreciate that. Go ahead and put some more questions in the chat if you've got any. One of the things that I wanted to highlight as well is we do have another workshop coming up next month. The topic of that one is funding for businesses to train new employees. And so we've got some experts from the National ABLE Network as well as Dynamic Educational Systems, Inc. coming to talk about that and some of the workforce development partnerships that will be there. I put the flyer into the chat as well, so you can sign up that way. One question that one thing that I wanted to ask the panel is, a lot of the conversation today when it comes to employment discrimination has been focused on that existing employee or past employees. When it comes to hiring employees, what recommendations could you give to businesses in their pre-employment status with their employees of the hiring process? What are some best practices you guys could throw out?
Sure. I mean, just be very careful about the questions you're asking. I mean, none of your questions during interviews or screening should implicate any protected class status. I mean, the easiest one, of course, is, you start talking about pregnancy or age while you're doing an interview. Those things just naturally come in conversation, but those are inappropriate things to talk about during an interview. Of course, if the applicant themselves starts talking about it, that wasn't you bringing it up, that was them. That's far different. But don't make sure that you are being professional and not talking about a protected class during an interview is the thing that sticks out the most.
And are there any other questions? Feel free to unmute. We've got about another minute left or so if anyone wants to ask any final questions.
I'd just like to add to what Ben said. When you're interviewing, make sure that the process truly is open Some companies sometimes try to disguise that they already have one person they want and they're just going through the motions with the others. Don't do that. Really have it really truly be an open process, and let the interview be able to change your mind, even if you have a preferred person before you go into the interviews.
Mm-hmm. Yeah, and as all of our panelists have mentioned today, there is technical assistance that's available through all of these agencies and organizations. And so as you have questions related to any of these topics, feel free to reach out to those organizations that serve your community or serve your state that these panelists represent here. And so I want to thank all three of them for their time and the effort that they put into creating these presentations. I hope you guys I hope everyone in the meeting had as good a time as I did, and learning about all of these great things. And so thank you for coming this month, and we hope to see you again next month. Look for more information about that stuff, and feel free to sign up for next month's presentation. And thank you again to the panelists.
Thanks, Dan.
Thank you for having me.
Yeah.